Who's in the house? Who else is in here?
My stepson is in here.
How many other people? Listen,
That's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah, he's right here.
Okay,
yes.
come out. Come down the road. Come on, come on.
The Connecticut woman accused of holding her stepson captive for years is back in the spotlight this morning as her defense team is racking up some big legal wins. Kimberly Sullivan is charged with assault, kidnapping, unlawful restraint, cruelty to persons, and reckless endangerment. She has pleaded not guilty to all those charges. Her 32-year-old stepson, known only as S, weighed only 68 pounds when he was allegedly rescued from her home back in February. This after reportedly setting the house on fire so he could be saved. But late last week, a judge granted Sullivan's defense team's motion to give her access to her stepson's alias and address. The state also must share the stepson's medical records with the defense team. Here to talk about these legal wins, Kimberly Sullivan's attorney, Ioannis Kaloidis. Ioannis, good morning to you. Thanks for coming on the show.
Good morning, Julie. Thank you for having me.
Of course. So let's just start with your reaction to these. You got a couple legal wins here.
We were pleased with the outcome from court last week. This is something that's kind of been ongoing for several months, this fight over the release of the medical records and whether there should be redactions or whether certain information should be shared with our client. We've been prepared to argue this for months. We filed our motion or our objection within days of the state's motion. We laid out the legal grounds. We always believed we were on firm legal ground with respect to that motion and with respect to the other motion we filed with respect to the complainant's attorneys.
Mm-hmm. And Ioannis, tell me, with respect to the medical records, what exactly are you hoping this provides?
So the medical records are something we always anticipated getting, and the state was never trying to prevent us from having those records. Those records are relevant. They're relevant to his injuries. They're relevant to the claimed injuries, and they might provide some light as to some information as to what he's alleging, blood tests, other conditions that he may be suffering from. There could be a lot of information there. There could be very little information there. But then the fight was never over whether we should get the medical records. The fight was over whether we should see what his new name is, his new alias, and his new identity, as well as his location.
Yeah, I wanted to ask you about that. So for what purposes would you want his new information, new address, new identity these days?
So the issue is not necessarily that we want his address. We don't necessarily want to know where he is. No one's looking for him or anything like that. The issue is, in part of our rules of discovery, names and addresses of witnesses are provided in every case. This is standard. It's in our practice book. So what the issue here was that the state was seeking an exception to the rules. The state was seeking at first to redact the name entirely, but then ultimately just for us not to share that information with our client. And the problem we had with that is the state did not make any showing, any legal argument or any legal basis for that information to be kept from our client. And that's where we had a problem with it. If the state is going to impose barriers on the defense, put up a wall between a defense attorney and his client, and ask a defense attorney to withhold information from our client, there has to be a good legal basis. There has to be more than, well, the accuser doesn't want her to know his new name. He doesn't want her to have that power over him, or he doesn't want her to know where he is. Well, respectfully, that's not a legal argument, and we're not going to start making exceptions and withhold information from defendants because accusers are uncomfortable with it or don't like it. As far as I'm concerned, criminal court is about the rights of the accused. That's how the framers set this up. That's how the Constitution was written. It's not about the rights of accusers. I know that's not a popular opinion, but that's how I approach the work I do.
Ioannis, we know that your client's out on a bond with a GPS monitor, a house arrest situation, and there are bond conditions. I would assume that would include no contact with him. Am I right about that?
Absolutely. The court actually issued a protective order the day we went to court, from day one. So there's been a protective order from day one prohibiting her from having any contact with him. She's obeyed by that order. She has no desire to change that order. She has no intention or desire to contact him. So that's a non-issue as far as we're concerned.
Thank you. I would have thought so, but just wanted to get the clarification while we have you here to be certain. So tell me, in terms of whether or not this case could be resolved without a trial, I know we're many months out from the last time we spoke, which was closer in time to the arrest and the charging. Has anything changed? Would your client be amenable to a resolution via some kind of plea agreement?
So, it's still premature to discuss the specifics, or I don't know if that'd be appropriate to discuss the specifics of this case. But as you know, any case can, result in some type of disposition, some type of agreement. What I could tell you right now, the state firmly believes, as best I could tell, the state firmly believes that what the accuser is saying to them is true, and they're going to proceed as if that is the case. I, on the other side, have a client who tells me she's done nothing wrong, and we've prepared a defense in accordance with that. So right now, it doesn't look like there's a resolution, but things always change. New information comes up. There's a lot of stress with the trial. There's a lot of risk associated with the trial. So is it possible that some resolution is reached? That's always possible, but as best we could tell, and as far as we're concerned, we're preparing for a trial.
Understood. And so tell me, is there a trial date yet that's been firmly set, Ioannis?
No. We're just going to keep going back to court. And the way our system is in Connecticut, we don't actually use dates certain for trial, except in rare circumstances. We would obviously be pushing for some type of set trial date at some point, but it is premature at this point.
Yeah, got you. Well, please let us know when you do have a firm trial date. There's a lot of media interest in the case and tough facts. And I've said it before, I'll say it again. Kimberly Sullivan is in excellent hands with you. Ioannis Kaloidis, thank you so much for coming on the show today.